On the 12th of February 2018, a fire crew and a highway patrol officer found a 19-year-old woman lying beside Tesla Road in the hills outside Livermore, California. She had been stabbed repeatedly and left there. She was still alive. Her name was Lizette Cuesta. She was flown to a hospital in Castro Valley, and in the time she had left, she told investigators exactly who had done it. Not a description, not a vague direction. 2 names of 2 people she knew. She died that morning. The prosecutor later described what she had given them as a very compelling dying declaration. That phrase is not journalism. It is a term of art, one of the oldest exceptions in the law of evidence, and it carries a specific and demanding meaning. It is also, as the cases in this video show, far weaker on its own than people assume. A dying woman naming her killer feels like the end of an investigation. In practice, it is the beginning of one, and sometimes it is not even enough to finish it. These are 5 real cases in which a woman used the last thing she had to identify the person who killed her. 4 of them ended in a conviction. 1 did not. The difference between them is the actual subject here. Lizette Cuesta was 19. She worked at a fast food restaurant in Tracy, California, and the 2 people she named were people she knew from that life, not strangers who found her on a dark road. One of them, Daniel Gross, later pleaded guilty in her death. His co-defendant pleaded not guilty, and her case took its own course through the Alameda County courts. And we are not going to state an outcome here that we cannot verify. What is documented, and what the prosecutor said out loud, is that the investigation had a direction within hours because a dying teenager on a gurney was lucid enough to give it one. Consider what that required of her. Not courage in the abstract. The specific and almost unimaginable discipline of understanding, while bleeding out on the side of a road in the dark, that the only useful thing left to do was speak clearly to a stranger in a uniform. Section 1. What a dying declaration actually is. Hearsay, as a rule, is not admissible. If a witness cannot be put in a chair and cross-examined, their words generally do not come in, because the defense never gets to test them. The dying declaration is one of the few exceptions old enough to predate the rule itself. The reasoning behind it is centuries old and frankly theological in origin. A person who knows they are about to die is presumed to have no motive left to lie. In modern American practice, the exception is narrow. It requires that the person believed their death was imminent, and that the statement concerned the cause or circumstances of that death. It is codified federally in the rules of evidence, and has counterparts in most states. Then, in 2004, the Supreme Court decided Crawford versus Washington, and rebuilt the entire analysis around the Sixth Amendment right to confront your accuser. After Crawford, the question is not only whether a statement fits a hearsay exception, it is whether the statement was testimonial, meaning made in circumstances whose primary purpose was to establish facts for a later prosecution. Testimonial statements from a person the defense cannot cross-examine are, with narrow exceptions, barred. That reordering is the reason this video exists, because it means the same dying words can be admissible in one case and inadmissible in another, based on the circumstances in which they were spoken. In 2011, the Supreme Court took up Michigan versus Bryant. A man named Anthony Covington, shot and dying in a parking lot, told arriving officers who had shot him and where. Richard Bryant was convicted. The Michigan Supreme Court threw the conviction out, holding those statements were testimonial. The United States Supreme Court disagreed and reinstated it, reasoning that the primary purpose of that roadside exchange was to meet an ongoing emergency, not to build a case. Notably, the statements had come in as excited utterances rather than as a dying declaration at all. The lesson prosecutors took from it is unromantic. Whether a dying woman's words survive to reach a jury can depend on who was standing there, what they asked, and why. There is one more piece of the modern doctrine that matters, because it is the law's answer to an obvious objection. If a defendant can silence the only witness against him and then argue that the silence itself makes her words inadmissible, the rule rewards the crime. In 2008, in Giles versus California, the Supreme Court addressed exactly this. A defendant who wrongfully causes a witness's unavailability, intending to prevent her from testifying, forfeits the confrontation objection. The doctrine has a blunt name: forfeiture by wrongdoing. It sounds like it should resolve everything in this video. It does not, because it requires the state to prove the intent to silence, which in a murder case is frequently the very thing still in dispute. Section 2. The call from the back seat. Denise Amber Lee was 21 years old, a mother of 2 young sons, living in Northport, Florida. On the 17th of January 2008, she was taken from her home by a man named Michael King. At some point during what followed, in the back of King's car, Lee got hold of his mobile phone and dialed 911 herself. What the dispatcher heard was a young woman trying to give away her own location while sitting next to her abductor, saying things aimed at him that were really aimed at the operator. She was not the only call. A motorist named Jane Kowalski, driving on a nearby road, saw a car with someone in the back screaming and banging on the window and called 911 to report it in real time, giving a running description of where the car was going. Officers may have been close by. That call was mishandled inside the dispatch center and never turned into a radio dispatch. Denise Lee's body was found 2 days later. Michael King was convicted of first-degree murder and other charges and sentenced to death in 2009. Florida executed him in March of this year, 18 years after the crime. Her family did not stop at the verdict. They campaigned for what became the Denise Amber Lee Act, which set statewide training standards for 911 telecommunicators in Florida, requiring more than 200 hours of training, and their foundation has pushed the same reforms nationally. The reason this case belongs here is precise. Denise Lee's own words did help convict her killer, but the thing that might have saved her was somebody else's call, and it failed for reasons that have nothing to do with evidence law and everything to do with a room full of people under load. Section 3. The phone call about the pills. On the 24th of February 2005, Rosemary Esser was driving to meet a friend at a movie theater near Cleveland, Ohio. She collapsed at the wheel, and her SUV struck a passing van. The crash was minor. She died at the hospital anyway. Before she lost consciousness, she used her phone to call a friend, Eva McGregor. She said she felt very wrong, and she said her husband had given her a pill before she left the house. That is not a name written in blood. It is a woman dying and confused, reporting the last ordinary thing that had happened to her. It was enough to make the family refuse the obvious explanation of a car accident, and enough to get a toxicology screen that would otherwise never have been ordered. The screen found cyanide. Her husband, Dr. Yazid Esser, was questioned and then left the country. He was gone for well over a year and was eventually arrested in Cyprus in October 2006 and returned to Ohio. His trial ran 7 weeks. In March 2010, a jury convicted him of aggravated murder for poisoning his wife with a cyanide-laced calcium capsule, and he was sentenced to life with parole eligibility after 20 years. Rosemary Esser did not accuse anyone. She described a pill. Everything that followed was built by other people on top of that one sentence. Section 4. The letter that was thrown out. Julie Jensen lived in Pleasant Prairie, Wisconsin. In the autumn of 1998, she was frightened of her husband, and she did the thing that every version of this story says you should do. She wrote it down. She sealed a handwritten letter and gave it to a neighbor with instructions to hand it to police if anything happened to her. In it, she wrote of her suspicions about her husband Mark's behavior and her fear of what she called her early demise, and she said plainly that if she were found dead, he should be the prime suspect. She also left messages for a local police officer. On the 3rd of December 1998, Julie Jensen died of ethylene glycol poisoning, antifreeze. Her letter became the centerpiece of the prosecution. In 2008, Mark Jensen was convicted of first-degree intentional homicide and sentenced to life. Then the law caught up with the letter. Through a chain of appeals reaching the Wisconsin Supreme Court, courts concluded that admitting Julie's letter and her voicemails had violated Mark Jensen's Sixth Amendment right to confront the witness against him. For the simple and unanswerable reason that the witness was dead and could not be cross-examined, the conviction was vacated. He was retried in January 2023. And this is the part worth remembering. The jury never heard the letter. They never heard the voicemails. Prosecutors had to rebuild the entire case out of physical evidence, medical records, computer search history, and living witnesses. It took a Kenosha County jury less than a full day. On the 1st of February 2023, they convicted him again, and he was again sentenced to life without parole. Julie Jensen's letter did not convict her husband. It did something arguably more important. It made anyone look in the first place. Section 5. The name that was not enough. On the 6th of December 2014, near Cortland, Mississippi, firefighters responding to a burning car found 19-year-old Jessica Chambers walking away from it with catastrophic burns. She was conscious. She spoke. At trial, first responders testified that she gave a name. Several of them heard it. The name they described did not obviously match the man the state had charged, a man named Quinton Tellis, and the defense built its case on precisely that gap. The state's theory was that the name was slurred by a mouth and airway already destroyed by fire, and that the physical and digital evidence pointed to Tellis. The defense argued the opposite, that first responders had heard what they heard, that it did not name the defendant, and that a case anchored to it should fail. It failed twice. In October 2017, the jury deadlocked and a mistrial was declared. He was tried again in 2018, and that jury deadlocked as well. Quinton Tellis was neither convicted nor acquitted of Jessica Chambers' death. Two juries could not agree. This is the case that should sit alongside the other four, everything people imagine a dying declaration to be. Jessica Chambers gave. She was conscious. She was speaking. She was heard by trained professionals with no stake in the outcome, and there were multiple witnesses to it. It still did not resolve anything, because the one thing nobody could do was ask her a second question. And that is the whole fragility of it. A living witness can be asked to repeat herself. She can be asked whether she is sure, whether she saw a face or only heard a voice, whether the name she gave is a first name or a nickname, or the name of someone else entirely who was there. Every one of those follow-ups is unavailable in every case in this video. What the record preserves is one utterance at the worst moment of a human life, transcribed later from memory by people who were simultaneously trying to save her. Two juries looked at that and could not agree on what it proved. It is uncomfortable, and it is also the system doing something close to its job. A hung jury is not a miscarriage. It is 12 people declining to convert an ambiguity into a certainty. Closing. 4 names, and one that could not be made out. Lizette Quester named 2 people, and one of them, Daniel Gross, pleaded guilty to her murder. Denise Amber Lee's call helped send her killer to a death sentence carried out this year, and rewrote how an entire state trains the people who answer the phone. Rosemary Esser mentioned a pill, and a toxicologist found cyanide. Julie Jensen predicted her own murder in a sealed letter that the courts ultimately refused to let a jury read, and her husband was convicted anyway, twice. What connects them is not the drama of a final word. It is that in every case the word had to be handed to someone who then did months or years of work. Quester gave investigators 2 names, and they still had to prove the case. Lee gave a location, and a dispatch system still had to act on it. Esser gave a symptom, and a laboratory had to find the poison. Jensen gave a suspect, and a jury had to convict him without ever hearing her say so. A dying declaration is not proof, it is a direction. Every one of these women pointed, using the last thing she had, and then had to trust strangers to walk the rest of the way. 4 of them were right, and 4 times somebody walked it. If this stayed with you, hit like and subscribe, and we will keep telling the real ones.